Hi, everybody. Thank you so much for joining us this afternoon. We are pleased to invite our partner, Mr. Ankit Sangwi, who is a partner in our dispute resolution department, to speak on the operation of judicial management order in Malaysia. Without further ado, and it's after 3 p.m. now, let us welcome our Mr. Ankit to speak on this particular chapter.
Yes, very good afternoon to all of you participating in this session today. So as you can see from the title that we have before us, I will be speaking on the operation of the new scheme accorded for under the Companies Act 1965, which allows for a new creation called the Judicial Management Order. And in this session, I will briefly deal with what are the relevant sections that govern judicial management order, how does it work, and how does it benefit the private sector or industries that are governed by companies or private companies in this country. So without wasting any more time, I will proceed with the session which commences now. So just by way of an introduction, the Judicial Management Order is something which we call, under a larger umbrella, we call it one of the methods of the corporate rescue mechanism. And it is provided for under Division 8, Part 3 of the Companies Act 2016, which came into force on the 1st of March 2018. And this corporate rescue mechanism under the new act is to be read together with a set of rules called the Companies Corporate Rescue Mechanism Rules 2018. The new regime of corporate rescue mechanism under the 2016 Act essentially introduces two new corporate rehabilitation mechanisms. Now, what are the type of corporate rehabilitation mechanisms that have been introduced? There are actually two types primarily, which do not exist in the old Companies Act in 1965. The first one is known as the corporate voluntary arrangement, and the second one, which is the subject matter for today, is the judicial management order. Now, these two different mechanisms essentially allow financially distressed companies to restructure their debts and to continue on with its business in a more effective and efficient manner. Previously, under the 1965 Act, there were limited options to allow financially distressed companies to rehabilitate. In fact, I wouldn't even call it rehabilitation under the previous rules, because the most common methods that were used was methods of liquidation, which essentially means that the receiver takes over the company, and essentially before they disperse off the assets upon liquidation of the company. The other method was, of course, something we call the scheme of arrangements. This is similar to the corporate voluntary arrangement, save that the corporate voluntary arrangement now actually provides for specific ways in which you can actually obtain a particular rehabilitation mechanism with minimal court intervention. So, since we are on this topic, I will just very briefly touch on what the corporate voluntary arrangement concept is. Yeah. So the corporate voluntary arrangement is conceptually similar to the current scheme of arrangement mechanism. Sorry, when I say the current scheme of arrangement, I mean the previous scheme of arrangement that existed under the 1965 rules. And in essence, the existing management of a financially distressed company remains in control of the directors of the company during the restructuring process. So this is one of the key differences between the corporate voluntary arrangement concept as opposed to the judicial management concept. The fundamental difference, as you can see in the second bullet point, is that the implementation of the debt restructuring proposal will be supervised by an insolvency practitioner. And as I mentioned prior to this, it is with minimal court supervision. I won't dwell with the exact process involved for a corporate voluntary arrangement, but in very brief words, if I could put it, what actually happens is the debtor company, the company who is actually seeking for rehabilitation, will be required to work with an insolvency practitioner to draw up the corporate voluntary arrangement proposal. Now, upon the filing of the necessary papers into court, of course, an automatic moratorium applies to protect the debtor company or the company seeking the rehabilitation. In essence, the moratorium prevents legal proceedings against the debtor company and also prevents a landlord from exercising any right of forfeiture and the right of re-entering onto the premises. So the real point that I wish to highlight here is the period of moratorium, which is actually a lot shorter, because from the time you file your papers, as you would see in the last bullet point, a meeting of the company's creditors will have to be held within 28 days of the filing of the papers. So you have a very short period of time where the moratorium or the automatic moratorium will seek to exist upon the filing of the papers. But 28 days from the time you have filed those papers, you will have to have the first creditors meeting. And at the particular meeting, or the creditors meeting, the creditors will vote on the CVA proposal, the corporate voluntary arrangement proposal. And what needs to be achieved is a 75% threshold of creditors' approval. And once this is passed, the proposal then would become binding on all of the creditors. Now, it's a common misunderstanding that people have when they see 75% of creditors' approval. What actually does 75% of creditors' approval actually mean? Really, what it means is it is the total value of the debt, and 75% has to match the value of the debt. So if there are 4 creditors and 3 creditors say yes to the CVA proposal, or they agree to the CVA proposal, it does not mean that you have met the 75% creditors approval threshold, because different creditors may have different sums that are due. So sometimes the 75% creditor approval could lie in the hand of one very large creditor. So essentially, one person's voice will have more power than the other, depending on the debt that is involved. Now, moving on to the actual area that I will be touching on today, what is judicial management? So simply put, the judicial management mechanism is a temporary court-supervised rehabilitation plan, which has been introduced through the Companies Act 2016, and its main aim is essentially to assist financially distressed companies to restructure and rehabilitate their businesses, and also to better serve the interests of their creditors. And this is really an alternative to the conventional method of winding up, which, as all of us know, really more often than not tends to not actually be in the interest of the creditors, because very often you would wind up a company and you would get nothing out of it. So one of the primary objectives of the judicial management mechanism is to give a company a new lease of life as a going concern, essentially a new breathing lifeline. And it's a process whereby the company's directors effectively relinquish their duties and temporarily place the affairs, business, and property of their financially distressed company in the hands of a qualified insolvency practitioner who is to be appointed by the court. So as you can see, the real difference here between this and the corporate voluntary arrangement mechanism is that the company's directors' powers essentially cease to exist for this particular period of time. And everything is vested in the hands of the qualified insolvency practitioner, who will then come up with ways in which they would think is most appropriate to salvage the company. Now, the court appoints a judicial manager who is an insolvency practitioner to manage the company. Now, the idea for this is that the judicial manager, whoever is appointed, will work out a rehabilitation plan that is acceptable to the majority of the creditors. An application by the company or its creditors for a judicial management order should contain a nomination for the judicial manager, and it has to be premised on one of the following grounds. The first is that the company has inability to pay its debts. The second is to ensure, or the second ground that you would actually be required to prove is that you would need to show that the survival of the company is essentially something that could exist provided that the judicial management order is granted. So you must be able to actually demonstrate this in your affidavit supporting the judicial management order as to how the judicial management order will give you that lifeline to remain as a going concern and to exist and to come out of the rut that you are currently in. Another ground would be that it is a better way to realize the assets as compared to winding up. So again, this is another thing that you would need to demonstrate. You will actually have to show that winding up isn't going to do the creditors any good. They're not going to achieve or obtain anything from the process of winding up, or whatever they obtain will be minimal. As opposed to, if you give me a lifeline right now, or a moratorium for 6 months to stop anyone from bringing me to court, I would be able to revive this company. I have certain contracts which payment is coming in 3 to 4 months. And all of this, once payment comes in, it recalibrates the entire company, bringing us to the point of beyond survival, which means that we are able to sustain. So that is another requirement. And finally, that the creditors will be in a better position than if the company was wound up. So as you can see under the second bullet point, item number 3, Roman 3 and Roman 4 are essentially somewhat tied up. It is really a point where you just actually have to demonstrate that it is really the interest of the creditors. Now, it is vital to bear in mind that there are criteria to be fulfilled both upon filing of a judicial management application and subsequently upon the granting of a judicial management order. So there are 2 different stages, of course, as you can see. And the initial judicial management application, it is more commonly done ex parte, which means it is only one party who applies for it. They get the order, and only later on there will be a second part of it, which is performance of the judicial management order. Now, who can apply for the judicial management order? In short, the company itself, of course, can apply for a judicial management order. The company's directors are also entitled to do so. And finally, the third bullet point, the company's creditors. So in short, even a person whom you owe money to is entitled to actually seek for your company's rehabilitation to ensure that they are able to realize certain debts that are due and owing to them. Now, the restriction to the judicial management order, there are several restrictions. The most important one is that the judicial management mechanism is not available to companies that are already in liquidation, or they're also not available to financial institutions or operators of designated payment systems regulated under the laws enforced by Bank Negara Malaysia, and companies whom are subject to the Capital Markets and Services Act 2007. Now, these restrictions are provided under Section 403, subsection B of the Companies Act 2016. The latter category, which is the company subject to the Capital Markets and Services Act, appears essentially to exclude public listed companies from the judicial management mechanism. In short, if you're a listed company, then this scheme or mechanism is not for you. However, just to put it out there, we do not know what the outcome of this is going to be, but very recently, a public listed company has applied for a judicial management order, and it's yet to be seen as to whether the mechanism would in fact be available to such companies whom are listed. Now, moving to my next slide, I will be highlighting the key features of the judicial management order. Now, first and foremost, the filing of the court application for judicial management automatically triggers a moratorium. The moratorium that I'm speaking of actually continues to exist while the court application is still pending hearing and decision. So from the very moment the application has been filed in court, the moratorium automatically exists in reality. So this is an automatic feature of filing for judicial management, as this gives the debtor company a few months of valuable breathing space. Now, the application must demonstrate to the court that the company is insolvent or is near insolvency. And what this means is basically that the company is at this point in time unable to pay its debts, or is about to reach a point where they would no longer be able to service the existing debts. So if you are able to demonstrate that, then the next thing that the court has to be satisfied is that the making of the judicial management order will essentially help to achieve the survival of the company, or the restructuring or rehabilitation of the company. That is an important point which I will come to, because the relevant case law leading up on this point actually deals with what are the factors that the court actually really has to be satisfied with. And as you can see, the most important thing is that it actually helps to achieve the survival of the company. And essentially, in turn of that, the survival of the company benefits its creditors as well. Now, any secured creditor can veto the judicial management application. Now, this is, of course, it can be seen to be a disadvantage of the judicial management mechanism as a rescue option. Prior to a couple of months ago, an unsecured creditor was not able to intervene in a judicial management application. And while I have not actually highlighted the case there, the case that I'm talking of is the case of Gold Page Assets Sdn Bhd against Unique Mix Sdn Bhd. And in this case, what actually happened was that 4 different sets of unsecured creditors applied to intervene in a judicial management application. And some of these unsecured creditors had obtained judgment or had pending legal proceedings against Gold Page Assets. Gold Page, of course, opposed the intervention applications and argued that the company's corporate rescue mechanism rules 2018 would not simply allow any unsecured creditor to appear and to oppose the judicial management application. But what happened then was the court decided that they can actually intervene. Although you are an unsecured creditor, you would still be able, as an interested party, to intervene in the proceedings, provided that your legal rights and interests in relation to the subject matter would be directly affected by the judicial management order. What then happened was there was a conflicting decision that was decided in the case of Million Westlink Sdn Bhd against Maybank Investment Bank Berhad. So we had 2 conflicting decisions. The Gold Page Assets case, which says that unsecured creditors can intervene, and the Million Westlink case, which says that unsecured creditors cannot intervene. They are both High Court decisions, but the good news to this is finally there is this issue has been put to rest, because the Court of Appeal has recently decided on the appeal in relation to the Million Westlink case, and it has now been decided with some firmity that the unsecured creditor or any unsecured creditors would be allowed to intervene in judicial management order proceedings. So essentially, point number 3 that you see there is no longer the current position of law. The decision of the Court of Appeal confirming this, which is Million Westlink Sdn Bhd's case, was only delivered sometime, I believe, during end of July 2020. So moving on to this, on point number 4, if the judicial management order is granted, the judicial manager has an initial term of 6 months to try to put forward a restructuring proposal to the company's creditors. The moratorium protection continues on during the judicial management order. Now, the judicial manager will seek to achieve 75% in value of the creditor's approval. This was the point that I had touched on earlier. And once this has been approved, the proposal becomes binding on all of the creditors. So as I've explained a moment ago, 75% means the value of the total debt, that is the sum total of the total debt owed by all creditors, and the value of 75% must be achieved in terms of the number of votes. Now, once the judicial manager has completed his task of restructuring and the creditors have been paid, that's when his role comes to an end and he would be discharged of his duties. The company essentially goes back to the directors, and the directors would assume their role in the company once again. Now, the next point is on the duration of the judicial management order once it is granted. Now, the JMO, the judicial management order, allows for a stay of legal proceedings for 6 months, which is a period of 180 days, unless it is discharged prior to that, and may be extended on the application of the judicial manager for another 6 months. Of course, the second 6 months, again, it would require the court to grant such an order. But in short, what I want to highlight here is that the moratorium could be stretched out up to a period of 1 entire full year. Now, within 60 days upon the order being obtained, the rehabilitation plan will be tabled at the creditors' meeting, and it has to be approved, as mentioned earlier, by 75% majority in value of creditors who are present and voting. Now, once the plan is approved, it becomes binding on all of the creditors, regardless of any issues that may be raised later on. So it is very important as a creditor to know your rights, to make a decision or make an informed decision whether or not you would be willing to accept the proposal that has been put forth by the judicial manager and whether it really is in your best interest. Of course, if you are the person applying for it, then your job is really to convince them that, look, this is in your interest, it is in my interest. It is really a win-win situation for both parties to ensure that you get paid and to ensure that I survive this current predicament. The procedures in applying for a judicial management order are as follows. The applicant would first have to advertise the notice of application for a judicial management order, and it is essentially a notice to the world at large that the application is made against the company or for a particular company. Now, the rules provide that any creditor or member of a company can make a written request, and by virtue of payment, which is to be made, they would be furnished with a copy of the application and the supporting affidavit. So essentially, once the advertisement for the notice of application is advertised to the world at large, people would come to know about it. And if you are a creditor and you wish to seek for the documents to be furnished to you, then you would be able to actually make a written request for the same to be supplied. Now, any person who opposes the application may file and serve an affidavit opposing the application within a stipulated period of time. Now, as we have seen, it is no longer just creditors who are allowed to actually oppose the application, but now even unsecured creditor will actually be allowed to actually oppose the application. Prior to this, unsecured creditors only had the right to oppose the nomination of the judicial manager candidate and nothing more. But right now, with the Court of Appeal decision in Million Westlink, that position has been firmed up. Now, continuing with the process, the process is indeed very similar to the winding up process by the court. The petitioner for a winding up order, as a lot of you would know, is required to advertise the petition, and any creditor or contributory of the company may ask for a copy of the petition. Any person opposing the petition may file an affidavit in opposition within the stipulated time, and any person who intends to appear during the hearing of the petition, either in support or in opposition to it, will be heard if he has served a notice of intention to appear on the petitioner. Now, the next heading is understanding the judicial management provisions in the Companies Act 2016. Now, the main provisions actually dealing with the judicial management concept or mechanism is Section 404, and it goes right up to Section 430. Those are essentially all of the rescue mechanisms that are provided for under the Companies Act. But what I will be focusing on right now is on Section 404 and Section 405 of the same Companies Act. Now, as you can see under the second bullet point, Section 404 of the Companies Act 2016 provides for this. An application for judicial management can be filed or may be filed if the company or its creditors considers that the company is or will be unable to pay its debts. So that is the first requirement. So whether the creditor applies for it or the company itself applies for it, the first hurdle you really have is to show that the company is currently unable to pay its debts or in the very near future will be unable to pay its debts. And the second point, which is the more important point that you will need to demonstrate, is that you must be able to convince the court that there is a reasonable probability of rehabilitating the company or of preserving all or parts of the business as a going concern, or that otherwise the interests of the creditors would be better served than by resorting to a winding up. The sentence sounds somewhat convoluted, so if I could just simplify it for all of you, it basically means that if the company's survival is going to benefit the creditors in comparison to a winding up, then a judicial management order should be granted. Now, the substantive test for a judicial management order is the next heading that I will be dealing with. And the substantive test, as I just very briefly touched upon, is the section that provides for it is section 405, subsection 1 of the Companies Act. Now, section 405, subsection 1 provides that where a company or its directors or a creditor makes an application under section 404, the court may make a judicial management order in relation to the company if, firstly, the court is satisfied that the company is or will be unable to pay its debts. Please focus on the word satisfied over here, which I will deal with very shortly. But this wording, satisfied, actually comes from section 404 itself. Now, the second limb is, of course, that the court considers that the making of the order would be likely to achieve one or more of the following purposes. First is that the survival of the company or the whole or part of its undertaking is a going concern. So if granting the judicial management order can guarantee the survival of the company or survival of parts of the company or its undertakings as a going concern, then it should be granted. The second is that the approval under section 366 of a compromise of arrangement between the company and any such persons are mentioned in that section. Now, this is very technical, but essentially it is what is required to be stated in your application, and you need to meet the requirements of section 366. And thirdly, which is again quite an important feature, is that it is the court has to be satisfied that it is a more advantageous realization of the company's assets would be effected by a judicial management order in comparison to that of a winding up order. So if you can meet these criteria, then the test is essentially met. So you can see that there's a two-limb test. The first is that the court is satisfied that the company is or will be unable to pay its debts, and the second is that the court considers that the granting of the order is likely to achieve one or more of the following purposes that you see under paragraphs A, B, and C on your screen. Now, I will move on to the next point, which is for me to deal with the case of Leadmont Development Sdn Berhad and Infra Sergi Sdn Berhad. Now, this is actually one of the foundation cases of the judicial management order mechanism in Malaysia. So, it is, although it was only a high court decision, and we do not have an authority of higher level because there was no, the appeals for some reason did not go on in this case. We have what we have right now is a high court ruling, and this is really what governs or has interpreted the provisions of the Companies Act and how they apply. So the recent case of Leadmont Development and Infra Sergi represents a landmark ruling in Malaysia, which being the first case to discuss and explain the background and framework surrounding the law of judicial management in accordance with the provisions governing Malaysia's judicial management scheme, which is contained in Division 8, Subdivision 2 of the Companies Act 2016. Now, the facts are briefly as follows. Leadmont Development was a property developer who was unable to pay the main contractor and subcontractors for the work done in respect of a project known as the Selayang Star City project. Now, to prevent the property developer from being wound up and to ensure that they are able to settle their debts, both the developer and the main contractor had separately applied for a judicial management order to carry out a proposed rehabilitation plan. Now, this was opposed by one of the secured creditors called Infra Sergi Sdn Berhad and 6 other nominated subcontractors of the project, who all applied to set aside both the orders granted by the High Court. As you can see, there were 2 orders that were granted by the High Court. One was in respect of the developer, and the other was in respect of the property owner in the case. Now, the court essentially allowed Infra Sergi's application to set aside both the orders. Even though the court initially granted the order to Leadmont, which was at an ex parte stage, the court later on decided to set aside the judicial management order, as the court subsequently found out that the order will not receive a majority approval, as Infra Sergi and the nominated subcontractor and the nominated subcontractors cumulatively hold 46.9% of the total value of creditors. So essentially, if all of these people are opposing it, there is no way that the particular mechanism or the proposal that has been put up by the judicial manager would be accepted. Infra Sergi alone, in this case, held 26% of the total value of creditors, which means that if Infra Sergi says no to the proposal, it's already the end of the road, because 75% cannot be achieved. The highest you would be able to achieve is 74%, and that doesn't meet the required threshold. So the court essentially pointed out that the order is futile. The initial order that was granted was futile, as any proposed scheme will not garner the requisite 75% approval of the total value of creditors. So this decision by Justice Wong Chi Lin, basically, although the order was granted at an ex parte stage, it was later on set aside on application by the creditors. Now, the analysis is as follows. In the case of Lidmon, the court had to first consider the background surrounding the implementation of judicial management provisions in Malaysia. Essentially, what they needed to consider was the legislative purpose of judicial management. Consequently, the court addressed the statutory test that the court would need to apply when deciding on whether to make an order for judicial management. This is the two-limb test which I spoke of earlier. The first is, what does satisfied under section 4051 subsection A mean? And second is the interpretation of going concern. So as you have seen under the limb number 2, I have broken it up into 3 more parts, which is A, B, and C, which I very briefly touched on earlier. Now, what does satisfied under section 405 subsection 1 subsection A mean? Now, section 4051A of the Act requires the court to be satisfied that the company is or will be unable to pay its debts. The court in Lidmont was of the view that the meaning of the word satisfied in section 4051A suggested that a higher level of persuasion was necessary as compared to the lower threshold for the term consider in section 4051B of the Act. Now, just for the purposes of your knowledge, if you don't have the Act before you, section 4051B, essentially the wordings used there are, the court considers that the making of the order would be likely to achieve one or more of the following. So essentially, the court in Lidmont has said that the word satisfied is really a higher threshold than the word consider. And in coming to this, in arriving at this determination, the Judicial Commissioner, Justice Wong Chi Lin, was persuaded by the judgment in a British case in Ree Harris Simons Construction Limited, which is a decision delivered in the UK by Justice Hoffman in 1989. However, it's still very relevant in the sense that the word satisfied is really a higher threshold, and it requires a higher threshold of persuasion, and that is really the first and the most fundamental hurdle you would need to actually cross when applying for the judicial management order. So you really must satisfy the court that I'm unable to satisfy the debts at this point, or it's just a matter of time in a month or 2 or 3 that I will no longer be able to pay my debts. So you must demonstrate that with affidavit evidence, with supporting documents, and everything that is required for a judge to consider the application properly. Now, interpretation of going concern, which is the words used under section 405 subsection 1B Roman 1, has been defined in both Words and Phrases Volume 2 and the International Standard in Auditing ISA 570. And it has been generally it is generally accepted that the meaning of this essentially means that it will continue its operations for the foreseeable future. That is what going concern means. Now, to determine whether the making of a judicial management order will enable the company to continue as a going concern, the court considers whether the making of the order would be a more advantageous realization of the company's assets as opposed to a winding up, which is what is prescribed under section 405 1B Roman 3. Now, finally, the court pointed that section 405 subsection 5A of the Act gives the courts wide powers to issue a judicial management order if the court considers that the public interest so requires the same. Now, the word public interest, of course, is very commonly used in a lot of legal case law and perhaps statute as well. But essentially, when it comes to the Companies Act 2016, the word public interest, at least when concerning a judicial management order, will have to be decided on a case-by-case basis. Okay. Yeah, the discharge or setting aside of the judicial management order is the next part that I'll be coming to, because this is what happened in Leedmont. As you all know, the order was granted, and later on, because it was realized, or rather the judge had come to a finding that 75% of the creditors' total would not be achieved, then the judicial management order is no longer sustainable and it must be set aside. Now, the statute only spells out actually 4 situations where the order can be discharged. The first is that the creditors do not approve the judicial manager's proposal. That is provided under section 421, subsection 5 of the Act. And when they say do not approve the judicial manager's proposal, we are really talking about the 75% threshold. So if 75% or more approve and the balance do not approve, then you have actually crossed, or rather you have met this criteria, and the party applying to set aside will no longer be successful on this ground under section 421, subsection 5. The second is when the purpose of the judicial management order has been achieved. This basically means that the insolvency practitioner has come up with a scheme, it has been accepted, and finally all parties have been paid their dues under the particular scheme. Once that has been done, then the judicial manager's duties have essentially been discharged, and the company, as I mentioned, goes back in the hands of its directors. That basically means that the judicial management order, or the ultimate aim of it, has been achieved, and again, that is a ground for to apply for a discharge of the order. The third reason is where the purpose of the judicial management is incapable of achievement. Now, this is provided under section 4241 and subsection 4242A of the Companies Act. So you can see item C and item A are in a way quite related, because when the wordings which has been used there, incapable of achievement, simply means that where 75% is not met. Finally, another ground where an order can be actually set aside is if the company's affairs, business and property are being or have been managed by the judicial manager in a manner which is or was unfairly prejudicial to the interests of its creditors or members, or if a particular act or omission by the judicial manager is or would be so prejudicial to them. This, as you can see, is provided under section 425 subsection 1A and 425 subsection 3 subsection D. In short, the first 3 are the more popular ones. Paragraph D, which you see on your screen, is somewhat less popular in court because it obviously has a higher threshold to achieve. Now, the court in Leedmont basically noted that there is a glaring lack of a provision in the Companies Act and the company's corporate rescue mechanism rules for the setting aside of a judicial management order by a creditor. Now, unlike in Malaysia we don't have anything that is expressly provided for except for those sections that we basically just went through. But the UK provisions expressly allow for the setting aside of an administration order, whereas in Malaysia we don't have it expressly provided for under statute. Now, the decision on setting aside the judicial management order. The court in Leedmont basically accepted that it did have and possess the inherent jurisdiction to set aside the ex parte order that was granted to Leedmont. The court's inherent jurisdiction is very wide and would allow for the setting aside if the order was obtained without full and frank disclosure, or was obtained with bad faith, which is what was another word for it is mala fides, or was otherwise defective on some substantial ground. Now, the court then proceeded to consider the various arguments raised on the alleged lack of full and frank disclosure. In the end, the court held that there should not be a setting aside on the ground of non-disclosure of material facts. Although more information should have been given during the application for the judicial management order, the applicant companies had disclosed sufficient facts to satisfy the threshold for the granting of the order. In short, the arguments that were raised by the creditors, which was on the basis that there was no full and frank disclosure by the applicant company, was dismissed by the court, because the court was of the view that there has been sufficient amount of facts that have been disclosed on the application, and therefore the order cannot be set aside on this ground of full non-disclosure of facts. Instead, the court chose another reason as to why the order had to be set aside, which is what I will come to now. Now, the court considered one further ground. Together with InfraService, 6 subcontractors of Sierra de Lima had exhibited letters to confirm that they were opposed to the judicial management order and wished to have it set aside as well. The total creditors' claim in opposition to Sierra de Lima amounted to 46.9% of the total value of creditors. InfraService debt alone, as I mentioned prior to this, amounted to 26% of the total indebtedness of Leadmont. This clearly meant that there was no possible way for the scheme that was proposed by the judicial manager to be approved by the requisite majority of the creditors. As we now know, the judicial manager's proposal will require 75% approval of the total value of creditors, and this cannot be achieved by the simple maths that applies on the facts. The court invited InfraService to give Leadmont and Sierra de Lima a chance. Leadmont and Sierra de Lima were the applicants here, just to refresh your memories. But the court essentially told them, look, I'm giving you a chance. Why not you allow the judicial manager to put forth the particular scheme and before the creditors. As creditors, why not you consider this particular mechanism that has been, or rather judicial manager's proposal that has been given over here. But on the facts of our case, InfraService insisted on proceeding with its setting aside application. So although the judge tried to convince them that, look, you should actually think about it, it's for your own good and so on, it is something that InfraService essentially decided not to proceed with, and they decided to stay with their rights to oppose the setting aside, to oppose the granting of the judicial management order, and they have then applied to set it aside. Now, while the court sympathized with Leadmont's plight and its attempt to rehabilitate the project, the proposal was now an exercise in futility. More than 25% of the total value of creditors would vote against any scheme or proposal. And finally, the key words that are really the highlight of this case is the court would not act in vain. Essentially, where something is no longer possible, there is really no point in dwelling further on this matter. So the judicial management orders that were previously granted ex parte were accordingly set aside. In any event, there is no requirement within the Act to show that the scheme would have been approved by 75% of the total value of creditors in order to maintain the judicial management order. Now, the next slide is whether or not the judicial management order mechanisms granted under the Act would be the saving grace for aiding businesses post this COVID-19 era. Now, when I say post-COVID-19, we really don't know how long more this is going to be hovering over our heads. But in essence, I would say that the appointment of a judicial manager or an insolvency practitioner can be really seen as a useful tool to give comfort to creditors, whereby it ensures a financially distressed company with sound fundamentals are being maintained and managed by professionals with relevant skill sets to assist the distressed companies out of this unprecedented perfect storm. It is safe to say that not many companies, especially those in the SME category, would have experienced such unprecedented times and will likely need all the expert assistance that they can get. Business owners should appreciate appointments of judicial managers. And this is really a suggestion that I'm giving, because it does not mean that business owners have lost their businesses by simply rejecting or opposing a judicial management order each and every time. It is really a temporary measure to assist this set of companies to regain their footing, which indirectly benefits you as a creditor as well. Now, while a moratorium may be in place pending the restructuring efforts, various applications may be filed to challenge or set aside such moratoriums. Now, it is important to fully review any scheme or proposal received to identify whether the organization seeking refuge through the various corporate mechanisms are merely abusing the process to delay the inevitable, which is it's the death of the company, aka the winding up of the company. So this is something that the judges really need to keep their eyes on, because what you do not want is an abuse of the process where parties who or companies who SMEs who are about to go through a lull period would be actually applying for this just for the sake of it, or rather to delay the process of realizing their debts to a point where they would then be wound up and really essentially nobody gets anything from it. So there have been instances where the courts have found that the applicants using moratorium or restraining orders are merely using it to delay the legal process when there is no actual restructuring or rehabilitation efforts that are really being undertaken. In some instances, parties even have used this type of mechanisms to further deplete assets of the company during this period under the grand idea of we are trying to rehabilitate the company. Now, before we close in for the day, I will just deal with some of the recent cases and deals in relation to the corporate rescue mechanism schemes available under the Act. The first is the case of Baraka Offshore Petroleum and PBGV Group against Mersing Construction Engineering. Now, in this case, the High Court allowed the ex parte application by Baraka and its subsidiary for a restraining order under Section 368, subsection 1 of the Companies Act. Now, upon expiry, the applicant sought for an extension of the restraining order, and this was opposed by some creditors on the ground that the applicants did not comply with the statutory preconditions prior to the grant of the restraining order. So the issue for determination was whether the preconditions in Section 368, subsection 2 of the Act must be satisfied at the initial stage of the application, or is it something that needs to be satisfied only upon the extension of the restraining order period. Now, the court in this instance held that creditors' application, they allowed the creditors' application to set aside this.
Sebelumnya refund bagi kami. So dia surat sebab ni 8, 12, 4, 7 ni dia surat ngek dengan ni gua. Tapi ni gua kami belum bayar.
Dah bilang 2. Cek nombor.
Belum bayar ke ni?
Sorry for this.
Sebab ni statement dia Jun punya statement tu.
You bilang berapa?
Ha?
You statement bila?
Statement dia ialah 25 Jun. So kalau bayar
Dah bayar tak? Cek nombor 58368.
XP68.
Okay, sorry, really apologize for that. I'm guessing someone must have accidentally turned on the speaker. So just to conclude on this point, the court basically held that it allowed the creditor's application to set aside the restraining order, and it held that the conditions under Section 368, subsection 2 must be complied with despite the difficulties in doing so due to the drastic effect of a restraining order, which would prevent creditors from pursuing legal remedies. So in short, the compliance of the preconditions under 368(2) must be met actually at the initial stage of the application and not at the later stage, which is when the extension of the restraining order period is sought for. In the case of CIMB Islamic Bank against Welcome Communications, interesting case, because in this case, two applicant companies, which is Welcome Communications and Rangkaian Minang, applied for a judicial management order. The application was opposed by CIMB Islamic Bank Berhad, who was the secured creditor and debenture holder of both the companies, and the order was subsequently dismissed by the High Court. Now, just for your knowledge, when we talk about secured creditors opposing, they will not be able, their right of vote on the total value of the shares would really be on its unsecured debt, which means that if you have a security for 5 million ringgit and your debt is 5 million ringgit, then you really will not have a vote to pass the 75% threshold. Only if your debt is, say, 10 million ringgit, then you will have the excess of 5 million, which is your right, or would be translated into the equivalent percentage of what that vote constitutes. Now, the issue under CIMB Bank, coming back to the Welcome case, was whether if the court dismisses an application for judicial management, whether a stay on the automatic moratorium under Section 410 would be allowed. Now, Section 410 basically allows for once a judicial management application is dismissed, a stay can be granted, or an automatic moratorium under Section 410 is meant to be allowed. But in this case, the Court of Appeal overturned the stay of the automatic moratorium granted by the High Court on the following grounds. In granting a judicial management order, the court must consider the real prospect of a company recovering its finances and operations. Strict proof and evidence is necessary, and the court cannot merely rely on surmise and conjecture as to ensure creditors are not frustrated from pursuing legal remedies against the company. The court must justly, economically, and expeditiously dispose of a judicial management application and any appeal process. This is in line with the effects of the order, which prevents any creditor action, and without any chance of rehabilitating the company, weight must be given towards protecting creditors' interests. Further, an element of bona fide must be reflected in a judicial management application, and the court suggested an approach to write to all concerned parties to obtain their views prior to the filing of the application and to disclose the creditor's views to the court. So, although the court did not elaborate on the threshold of strict proof and evidence, it is suffice to say that sufficient evidence must be placed to satisfy the requirements under Section 404 and Section 405 prior to a judicial management order. There must be a fine balance between rescuing a drowning company and to protect the creditor's interests, to avoid an abuse of process of the court. In short, a stay will not be granted willy-nilly, and you will still have to prove a lot more, and just by virtue of a dismissal of a judicial management order, you will not be able to seek for a stay on that. In Sham Chin Yen and 15 others against mentioned properties Sedan Berhad, the facts were as follows. This is, I think, the last case that we'll be dealing with. The respondent was a housing developer and initiated a scheme of arrangement. So this is not a judicial management order, it's a scheme of arrangement. And they obtained a restraining order under Section 368 to restrain any other legal proceedings against the company. The appellant comprised of 15 condominium purchasers who had earlier filed legal action for LAD, liquidated damages, against the respondent due to the delay in delivery of vacant possession of the condominium units. Now, in this case, the respondent obtained an ex parte order in November 2017 to convene a creditors' meeting for a scheme of arrangement, and further to restrain all other forms of proceedings. The scheme was approved by creditors on the 14th of December 2017. Now, the appellant sought to set aside the ex parte order, and interestingly, while this application was still pending, the respondents secretly obtained a second ex parte order in February 2018, which sanctioned the scheme of arrangement and maintained the restraining order given in the first ex parte order until the terms of the scheme is carried out or implemented. So what happened then? Of course, the appellants challenged the second ex parte order, and this was dismissed by the High Court. And this was what was held. The respondent's action to file a second application in a different court to sanction off the scheme of arrangement when there was pending legal challenge to the first ex parte order was deemed to be an abuse of the process of court. Since the first judge had given directions for the respondent to convene the creditors' meeting for the scheme of arrangement and to restrain of proceedings, it is only fair for the second application to be heard by the same judge. This is to maintain the High Court's visionary duties over the scheme and to ensure that the views and interests of those who have not approved the proposal are preserved. The respondent's action of obtaining the second ex parte order without the knowledge of the appellants renders their actions to be mala fide against the appellants, and the Court of Appeal set aside both ex parte orders accordingly. These are two recent deals that I wish to highlight. First is the creditors of Kinsteel Group Berhad, whom had agreed to a proposed scheme of arrangement several months ago. Now, creditors of steelmaker Kinsteel Group Berhad have approved a scheme of arrangement to rescue the company from its PN17 status, which is issued by Bursa Malaysia. And the scheme of arrangement involves reducing its share capital, disposal of properties, and fundraising. These are the mechanisms that have been proposed under the scheme of arrangement. It also offers its corporate guarantee holders RM 25 million worth of irredeemable convertible preference shares and redeemable convertible preference shares each. Companies may fall within the ambit of PN17 by having its shareholder fund equal or less than 25% of the total issued paid up capital of the listed company, or if a receiver or manager has been appointed to manage at least 50% of the total assets listed under the company on a consolidated basis. Now, adverse opinions on the company's latest audited accounts or the ceasing of all major operations may also contribute to the company's PN17 status. The next deal is the deal in BIMB Holdings to transfer listing status to Bank Islam Malaysia Berhad. And this was quite recent as well, just before the implementation of the MCO, December 2019, BIMB Holdings Berhad had proposed a series of restructuring exercises that was intended to move its listing status to its subsidiary Bank Islam Malaysia Berhad. Details of the restructuring plan included placement of new BIMB shares up to 800 million ringgit, which will go towards settling an outstanding sukuk under the Lembaga Tabung Haji. Now, a scheme of arrangement will take place to pay warrant holders in cash consideration for the cancellation of exercise rights in respect of the warrants. The group will also undertake an internal reorganization whereby stockbroking and leasing subsidiaries will be sold to Bank Islam according to the net asset value of the units in an effort to simplify the corporate structure of the company. These exercises will be an effort to expand to its customer base and improve the position of Bank Islam in the Islamic finance and Islamic capital market. So what you can see is, apart from the judicial management order, there are also various other methods that are accorded for under the Companies Act, including other forms of restructuring through schemes of arrangements and so on. Now, in conclusion, I will just round up by saying this. The process of judicial management is generally beneficial to all parties concerned, at least most of the time. It can be seen quite regularly to benefit the shareholders as their investment is not totally lost. The employees of the company also benefit as they will still remain under employment and be receiving payments or salaries. And the unpaid creditors are also able to recover some, if not all, of their debts. So really, this is not just a win-win situation, but it's really a win-win-win situation because all parties tend to benefit from it, provided, of course, there is earnesty on the part of the company seeking rehabilitation, and the judicial practitioner really comes up with a proper scheme or proper proposal which really is in the interest of everybody. Now, parties that are planning to apply for this rescue mechanism should take note that the courts in granting the order will consider the two-limb test laid out by virtue of Section 405 of the Companies Act 2016, which I touched on earlier. However, ultimately, the main consideration would lie on the courts or in the hands of the courts in deciding whether its inherent jurisdiction in setting aside the JMO is provided for, and whether the courts are satisfied with the justifications provided by the company applying. Now, thank you very much, ladies and gentlemen. This brings an end to our session for today. And yes, if all of you or any of you have any questions, then please feel free to ask. Thank you.
Thank you, Mr. Ankit Sangwi, for this meaningful session. I'm sure it has deepened your understanding and insights in relation to the key features, the recent development of judicial management order, and of course, thank you, Mr. Ankit, for explaining the judicial test in granting a judicial management order at length. If you have any questions, you may raise it now. We will allocate a few minutes for our Mr. Ankit to answer them.
Give a minute or so, then we'll have to just just chat.
Thank you. Okay, An evaluation form will be sent to all attendees via emails after this session is officially ended. Please fill up the form and email it back to the sender. And thank you again all for joining us today. See you soon.
Thank you.